We talked quite a bit in the first panel about the Sullivan case itself and about some of the cases that apply it. When I think about defamation claims in the news media, a case that I used to use in the classroom a lot, and one that I still use as kind of a cautionary tale for journalists, involves Rolling Stone magazine in 2014. This was a case that involved a cover story that went horribly awry when key facts of it involving an alleged gang rape on campus at the University of Virginia turned out not to check out. Turned out that the freelance journalist who authored this piece had holes in her reporting, and that certain caution flags about the article were missed and overlooked and bypassed. As a result, even though the lead plaintiff in the case, an administrator at the University of Virginia, was deemed by the courts to qualify as a limited purpose public figure, despite the Sullivan bar, the claim cleared the Sullivan bar, and the plaintiff was awarded $3 million in damages from the writer and from the publication, ultimately ended in a settlement. And so that case kind of illustrates, and we maybe talk a little bit more about the facts of that if we have time, but that case sort of illustrates that it's eminently possible post-Sullivan for a plaintiff who is wronged, even under the public figure standard, to recover damages. And so while Sullivan is certainly a muscular defense for news media, it's not a get out of libel free card. The Media Law Resource Center, which is a nonprofit organization based in New York, to which a lot of news organizations belong, is sort of the authority on libel law and libel verdicts. They do an annual survey looking at damage awards against news organizations. And interestingly, they did sort of a recap on Sullivan. There's a very authoritative report on the MLRC website that those who are interested in this subject, I would advise you to dive in and check out. They surveyed major news organizations around the country about their experience facing libel complaints. And they looked at the window between, basically a 20-year window between, the window was between 2009 and 2021, right? And in that window, they were able to identify, asking these news organizations, 246 cases that were filed against major news organizations. And although the news organizations were successful in 3/4 of those cases, and 75% of those 246 cases, the news organizations did end up prevailing. In only a small minority of those cases, 16% they found, was the Sullivan actual malice standard the dispositive issue. And so it did not turn out that the majority of those dismissals were obtained on Sullivan public figure bases. And so that shows you both that while it's a powerful defense, it has its limits, but also that there are lots of other defenses in the law that protect the ability to make an honest mistake when you gather and publish information, particularly about public affairs, the thing that the First Amendment was most designed to protect our right to discuss and debate. So I asked each of our speakers to take a few minutes to respond to kind of a prompt that I gave them. And I'm going to give you that prompt, and then I'm going to ask them to go down the line, starting with Rod Hicks from SPJ. What would be the consequences for journalism if libel law were, to use the Donald Trump term that he used during his first campaign, rolled back to make it easier to recover damages? What are your thoughts, your observations, your experience about the extent to which libel verdicts, or just the fear of libel verdicts, affect journalism, and in particular how journalism would be impacted if the legal system were adjusted to make it easier for public personalities to recover libel damages?
Okay. First, I think that rolling back Sullivan would have more of an impact on smaller news organizations and individuals than it would on, the big companies like CNN, for example, because I can't imagine the New York Times or the Washington Post saying we're going to go lightly with these public officials and reporting what they're doing out of the threat that we might get sued for defaming them. I think that there may be times, or they may beef up their legal budgets, and
nothing wrong with that, Lieta, right?
and they'll also be more careful in how they go through the stories and edit stories, have the lawyers looking at it. But I think by and large that you won't see much of a difference, because really Sullivan is really more targeted toward mistakes. And so an organization like the New York Times, CNN, the big ones in the country, they're going to be as careful anyway. That's part of how they do business. They're going to be careful so that they don't mistakes, because that's where you get dinged at. But I do hope that whatever happens, that provable truth still matters. I'll leave it there.
Eriq?
Yeah, I have a couple of different takes. One is probably not controversial, and one probably is. The non-controversial part is I do think that it would degrade journalism. I think, it's probably true that the Washington Post and the New York Times, would aggressively go forward with strong journalism. On the other hand, oftentimes working in journalism, you have cease and desist letters come from powerful people, and those are letters that basically put you on notice that what you're about to report is false. And in response to those letters, a lot of journalism outlets just go ahead and publish anyway. But I think that there'd be some reflection on whether that's wise. I think that if you look at the UK, for instance, I know that a lot of book publishers, when it comes to some of their most controversial books, have decided to not publish books there. And so I think that would be, and a prologue for what might happen. The other part of what I think would happen is a little bit more controversial, which is I think that the reputation of journalists would actually rise. I think that the quality of journalism would go down, but on the other hand, I think I agree with the statement on the last panel that a lot of this is about power, and basically putting journalists in their place and eroding their power would give the people who are their rivals, whether it's political figures or celebrities, a bit more control over what's published, and so they wouldn't have to attack journalists as much. And for some weird reason, I think that might actually boost the standing of many journalists, even though they're not doing as quality work. Unfortunately, I don't think the trade-off is a good one. I don't think that democracy depends on a popular fourth estate, but I think that's basically what we might see.
Lieta?
Is my mic working? Can you all hear me?
Let's see. Is Randy saying no?
So I agree with what Rod said. I think you'd see a really disproportionate and tragic impact on small publications, which ironically tend to serve flyover country and middle America, where we're already in news deserts and don't trend liberal necessarily. And so it would have this sort of paradoxical unintended consequences that some of the publications that speak with a conservative voice to middle Americans would be driven out of business. And I've represented clients who fear that. I represented the Carroll, Iowa newspaper a few years ago in a libel suit where they were sued by a police officer who had shacked up with a 16-year-old girl. And they won, and yet it nearly drove them out of business because Iowa didn't have an anti-SLAPP law, and their insurance retention alone was, a burden to them. So I think that's true. I also agree that the big dogs would continue to be aggressive, but I do think that you would see certain stories not reported as quickly. Someone on the last panel said they've never been in a newsroom where the journalist says, well, we're pretty close, right? Let's just go with it, even if we're wrong. That's true, and so often we don't rely on actual malice to get the news out, but we do rely on things like the fair report privilege and are there public records, right? And I think of stories like the stories that broke the Me Too movement, right? You didn't have public records there. Instead, you were dealing with decades-old stories and non-disclosure agreements, and he said, she said, and questions about what is rape, really, He says it wasn't, she says it was. without an actual malice standard, I'm not sure those stories get told as quickly or at all, and I think they're really important stories.
So you just referenced something that I would like to unpack a little bit more for people who don't practice in this area, which is anti-SLAPP law. You mentioned that Iowa doesn't have one, and so the defendants in that case did not have the ability to invoke an anti-SLAPP statute. Can you sort of unpack for the people, again, who don't practice in that area, what those laws are and how they work and why they're important?
Sure. So the anti-SLAPP laws were a creature of the California legislature. It has the first and oldest anti-SLAPP law, and many states have followed suit and adopted their own. My state had one that was ruled unconstitutional. It no longer has one. Iowa has been trying to get one, but they all look a little different in every state, but the idea is that powerful people file what are called strategic lawsuits against public participation. They file slap suits to slap back the speech and basically to chill speech and to change the narrative, even if they can't ultimately prevail. The lawsuit itself is enough to stop people from saying bad things about them. And so anti-SLAPP statutes came into existence that, depending on the state you're in, create a higher burden for the plaintiff to show his case has merit or it's automatically thrown out, and then also have attorney fee provisions, because typically in a libel case, even if you win as the defendant, you pay your own fees, and those can be crushing. And that can be a victory in and of itself for the plaintiff, as we saw, for example, with Gawker. So anti-SLAPP statutes create higher burdens and easier paths to dismissal in many states, and then also have a fee-shifting provision. They're great in the states where they exist and where they are strongly worded. They tend not to apply in federal court, so sometimes you have to pick, do I want a federal judge or do I want the benefit of the anti-SLAPP statute? But that's it in a nutshell.
Yeah, I'm glad you mentioned that, right? There's a very vigorous split of authority about whether the state anti-SLAPP statute travels with the case into federal court or not. Different circuits have different views about that. But one of the ways to answer that conclusively would be to just pass a federal statute, but one has languished in Congress despite numerous attempts over the years to get Congress to take it up and
right.
And pass
you're
it.
Also picking, when you choose federal court or anti-SLAPP statute, do you want the Iqbal-Twombly pleading standard or do you want a state pleading standard coupled with anti-SLAPP? And those can be really very strategic, difficult decisions.
So because we have a panel of journalists and journalism advocates, I feel compelled to be the devil's advocate here and to pose you a devil's advocate question, donning Justice Gorsuch's robe for a second. And I read from his dissent that was referenced in the last panel. In 2021, dissenting from a decision not to take up a case that might have tested the Sullivan standard, Justice Gorsuch wrote that Sullivan, as it is currently understood, is, quote, an ironclad subsidy for the publication of falsehoods by means and on a scale previously unimaginable, end quote. So playing devil's advocate, right, when Sullivan is decided in 1964, the media landscape that the court is contemplating at that point consists of newspapers, magazines, radio, and not very much else. The first evening TV newscast debuted in 1963 on CBS. The other networks didn't follow suit until even after Sullivan was on the books. So this is the universe that they are contemplating and thinking about when they adopt the Sullivan principle. And I wonder, right now we live in a world where, to use the Mark Twain formulation, Twain was clearly anticipating Twitter when he said this, that a lie can travel around the world and back again while the truth is still lacing up its boots. Is it time to consider tweaking the standard? During the first panel, we heard Alexandra Gutierrez say that, well, of course, we would never, in my newsroom, publish false or unverified information, not because of lawsuits, but because it's not ethical, it's not professional, it would be damaging to my reputation and my employers. But we live in a different world now, and is it time to revisit the standard, given that a standard that was created for the New York Times is now protecting 450 million Twitter account holders, very few of whom have any journalism training or feel that they're encumbered by any journalism ethics? So who wants to take that?
No one's suing them because they don't have any money. And so, like, this idea that we should get rid of Sullivan to put an end to the cesspool that is social media, like, those people aren't inhibited by the law, and they face no repercussions. So I just think it's a false paradigm.
Yeah.
Honestly, if you look at Sullivan, I think the facts are kind of a little bit like social media. I mean, what was objected to was not something that came from New York Times reporting. It came from an advertisement. It came from a third party who had placed an ad in the Times, and the Times was being held responsible for that. So the justices at that time were looking at speakers beyond reporters, and they were thinking about big issues of speech. I still don't think that the breathing room that the justices saw that the First Amendment required, that free speech required, has changed that much just because there's more speakers out there or because people have a platform. That I don't think really has changed.
Yeah, the thing I'd say is that when you look at Twitter users, I don't think that people who are on Twitter are really the ones who matter to the guys who claim that they are being defamed. And let's just remember that we need to keep the basic protections that the First Amendment gives us. So we should be able to say, much of what we want. We should be able to do that. And if you're just a guy, you're not a public figure, you're just a regular guy saying, I hate the president, that's not really harming the president. A lot of people hold that opinion. And I just don't see that. Now, I don't like all of the misinformation that I'm seeing out there in the universe now as well. But, where do we stop? We need to preserve the right to free expression, though.
Can I make one more comment about the subsidy point? Even if you have a slam dunk actual malice motion to dismiss at the Rule 12 stage, if you've gotten a complaint from a real law firm, Claire Locke, Charles Harder, a real law firm who knows how to draft a complaint, and it's a real plaintiff, right? So we're not talking a pro se case, and you have a slam dunk motion to dismiss. By the time you get up to speed on the facts and brief it and prepare for a hearing and go to a hearing, if you're at any major media defense firm, count on $100,000, okay? Just to get a case dismissed at the Rule 12 stage. And that's not counting discovery and trial. I mean, these cases are incredibly expensive. So even with the actual malice, I mean, what is that, 2 journalists' salaries, right, that they're putting toward getting a case dismissed?
So even though we're understandably focusing, as we should, on federal case law here, defamation is a creature of state law. And in fact, that means, right, state courts and state legislatures. And you heard Matthew Schaefer address a little bit in the last panel the pending legislation in Florida that seems to be aimed at teeing up a facial constitutional challenge to give the court an opportunity to revisit Sullivan. Just to sort of introduce that legislation a little bit and invite, I think Eriq might be a good one to lead off the discussion of this because he's done some thinking about it. But so the Florida bill that's pending right now, the principal one, would drastically kind of recalibrate the way libel law works in that state. And among the changes that are being contemplated are that the understanding of who qualifies as a general purpose public figure would be greatly narrowed so that essentially that public figure designation would apply only to people who are either elected or appointed government officials and to no one else. Right? So everybody else would have the benefit of a greatly reduced burden to prevail in a libel case. Also, there would be statewide venue for libel claims. A claim could be brought anywhere in the state based on the theory that the internet is accessible anywhere. It wouldn't even be necessary for the plaintiff to show that the story was read or accessed or had any impact in that jurisdiction. It's enough that it's theoretically accessible in that jurisdiction. A story that is based on unnamed sources, the information that's provided by undisclosed sources would be presumed to be false under the law, shifting the burden to the speaker to defend the truth of the matter, right, which is upends the traditional burdens that we've come to understand in libel law. that's among the many features of this proposed legislation. So, Eriq, I mean, what are your thoughts about, as you kind of looked at and studied that legislation, what the impact of that would be if that became the prevailing understanding of the way libel law works in America?
Well, I think that legislation was expressly designed to overturn Sullivan, to basically get the Supreme Court to tackle this issue. And it goes to show you that if Sullivan was overturned, that this would become much more of a state issue. While there would be states like Florida that would make it really tough to publish stuff, there are other states like New York which have already codified Sullivan. So there would be certain regions of this country where actual malice standard for public figures would still be good law, and to me that raise interesting issues, just like it raises interesting issues when Roe v. Wade was overturned, and now all of a sudden we have a federalist system where certain states are doing something and other states are doing other things. And I think that a lot of news organizations might start strategically planning for that day. Maybe they limit access to their articles in certain states. Maybe they geo-block articles in the red states. I mean, it's possible. Actually, I'm not too concerned with the public figure stuff from the Florida bill. I think it's pretty clearly unconstitutional, and I think that the courts will rule that as such. If there is one aspect of that bill that causes me a little kind of concern, it's that anonymous sources could be presumed false, because I don't think that there's as much of a bedrock legal case law support for how we treat anonymous sourcing, and that could tip and be of concern, because there's a lot of reporting out there that's done based on anonymous sourcing. A lot of journalists don't want to give up their sources, so that could hold journalists back some. And a lot of publications maybe even go too far in publishing gossip. But that's something to watch. I definitely think.
Can I just say this? When I look at laws like what DeSantis is trying to get passed in Florida, it just takes me back to, it was clear from when this country started that the whole idea was to hold elected officials accountable. And it sounds like what he is trying to do is to allow elected officials to do whatever they want and not be challenged at all by a robust press. That's just the opposite of how we started this country.
Lieta, thoughts on that legislation and the impact of it, if that should become the prevailing standard?
Well, it's clearly unconstitutional.
Glad to hear that.
And it's clearly designed to tee up, consideration of those constitutional questions. I'll let the scholars speak as to whether that's really likely. I tend to agree with them that it's not. As a practitioner at a law firm, the public figure debate is interesting. And look, the DeSantis stuff is super extreme, right? But the thing I'd say about the existing public figure and limited public figure standard under existing law, it's already really malleable. And, if it's a clear public official, you might bring a motion to dismiss on actual malice grounds. And if it's a clear general purpose public figure like Beyonce, right, you might bring a motion to dismiss on actual malice grounds. But if you're in limited public figure land, you keep your powder dry until summary judgment, because you just don't know how judges are going to go on that. And I'll give you a recent example from Minnesota. It's long been the law in Minnesota that public school teachers are actually public officials, right? So there's a case where a second grade teacher was criticized by a TV station for not paying enough attention to the kids while on recess duty. And it went up, and the Court of Appeals said, second grade teacher on recess duty, you're a public figure slash public official, you have to show actual malice. Fast forward to a few years ago, a girls varsity volleyball coach sued some parents, non-media, some parents for gossiping about him, saying mean things about him. They were pro se. It went all the way up to the Supreme Court, and the Supreme Court said, okay, second grade teacher, you're a public official. Girls varsity basketball coach, you're not. All you have to prove is negligence. For any of you who were in second grade and went on to play varsity sports, I think we can all attest, like, who had more influence on our lives, right? Who could have more easily molested us? Who did we ride a bus with? Who influenced our worldview more, right? And to my point, it's just an extremely malleable standard already without more intervention.
We should actually, I think, elaborate just a bit about this notion of a limited purpose public figure, right? The first panel didn't have time to get into that distinction. They were focused on Sullivan, but limited purpose public figure is not a creature of Sullivan. It's a creature of the cases that come after Sullivan. Chiefly, there's one the court decided, Butts versus Curtis Publishing. That's a case that involved the head football coach at the University of Georgia and allegations that he participated with the head coach, Bear Bryant, at the University of Alabama in fixing the outcome of a football game. And in that case, and in the cases that followed, the court recognized that it's possible that public figure status is not all or nothing, right? That it's possible that while there are pervasively famous people who are either public officials or public figures, right, the people that we're all on a first name basis with in Hollywood, that it's possible to be a public figure for purposes of commenting on your performance of certain public duties or responsibilities, right, in the way that I mentioned the associate dean at the University of Virginia. Certainly not a household name, not a Hollywood superstar, not an elected official, but somebody who had a certain sphere of public responsibilities. And in that case, the court says, well, for purposes of commenting on her performance or discharge of those governmental duties, for that purpose, she's a public figure in the same way that commenting on whether Wally Butts was an honest or a dishonest football coach was protected by the Sullivan actual malice standard, right? And you mentioned, talk a little bit about that uncertain game of trying to determine who qualifies for that, because you mentioned school teachers. That's not an uncontroversial proposition, right? I mean,
right.
Depending on what state you're in, a school teacher may or may not qualify as a public person, right?
Yeah, that's right. And I think as outside counsel, when you're looking at, do I have a Rule 12 motion here on actual malice grounds, right? First you have to, are they a public figure or a public official, right? Thumbs up or thumbs down, that's the only way you get to actual malice. And then you look at the pleading and does it state a claim for actual malice? But on that public figure point, it's just, we have lots of cases involving high-profile doctors, right? They go on the speaking tour. They take out advertisements. They have appointments at universities. They are famous within their field. And the story is about how they botched a surgery, right? Or this, that, or the other. Are they public figures? Courts are kind of all over the place on that. Then there's people who, I had a case recently of a woman who was an anti-vaxxer, right? She had taken out billboards. Does that make her a public figure? That's a close call. And so I think my point is, in those close call cases, you don't bring a Rule 12 motion. You get into discovery and build your case so that you don't want a bad opinion at the Rule 12 stage that you then have to overcome on summary judgment after you've conducted discovery. And so you just wait to make that argument until you have the facts you need.
The example of the coach and the doctor are, I can understand, but what would be an argument that a second-grade teacher is a public figure?
She's employed by the state. Yeah, in the decision, is that second-grade teachers are with students 8 hours a day. They are paid by the taxpayers. Mm-hmm. They have great influence and access to these children, and that we, the media and the public, should have breathing space to discuss them.
So any person who has a public job, therefore, is a public figure?
That's where we would like to start as media defense counsel.
Looks like I left state government at the right time. Since Eriq focused in on this feature of the bill, Rod, I'm going to give you a chance to put your ethics czar hat on, if I could put that on you, and talk just a second about, because for people who aren't journalists or maybe don't spend a lot of time thinking about the way journalists do their jobs, could you talk a little bit about anonymous sources or unnamed sources? Actually, by the way, don't use the term anonymous sources. I just slipped up there, but I always use unnamed sources, and we'll talk about why unnamed source is, to me, the preferable term. But the practice of using unnamed sources in journalism, do the journalists know who these people are when they're quoting a person without a name?
I'm glad you asked that, because a lot of people don't know the answer to that. Yes, the journalist who does the story knows who the person is, so they're not anonymous to the journalist. And in most cases, there's someone else, a manager, an editor, who also knows the identity of the unnamed source. Everywhere that I've worked, and I've worked in 8 newsrooms, including the Associated Press, where you sat, and everywhere that I work, anonymous sources are an absolute last resort. And it's kind of hard to even get an anonymous source in your story, because the first thing they ask is there anybody else who can provide us with this information? And you say, I don't know. Then you have to go and look and try to find it from someone who will attach their name to it. And then you look at the motives of the person. You know, why do they want to be anonymous, and does that raise any red flags? And I don't know about other news organizations, but at the Associated Press, you would not be allowed to make some outrageous claim in a big story about an individual and not have your name attached to it. And so it's not, I know that there are a lot of Washington stories that use anonymous sources, but just day to day, they're not used, and nobody really likes to use them. And there's always a process to go through before a decision is made. It's not just the reporter makes an agreement, says, okay, you don't want to be named, fine, and it happens. It does not happen like that.
No, thanks for that clarification, yeah. I wonder if Eriq and Lieta could sort of jointly walk us through, Eriq on the journalist side and Lieta on the side of a person that, among her many hats that she wears, is doing pre-publication review for news organizations. Sort of what that process looks like. I think particularly for the law students, maybe anybody who's thinking about going into this area, you're going to spend a lot of time doing this, walking through the formulation of the story with the journalists. And so I guess, Eriq, maybe you could talk a little bit about both ones that you've experienced or witnessed in your journalism life, and then Lieta, maybe some of the sort of red flag things or yellow caution flag things that one might look out for that would cause you to probe more deeply into how that story came together.
Sure. First, let me mention that, basically every year I go through libel training. I've tried to argue that, like, I'm the Paul Goldschmidt of CLE credit and I don't need to do it, but they make me do it anyway. So
I appreciate that baseball reference.
Thank you. I tried to melt it for here. But for every story that comes out, we have a lawyer that looks over it, that looks to see if there's any problematic bits, whether or not we could verify it. Where's this information coming from, and is it phrased, accurately? Usually lawyers like working with me because I'm dealing with a lot of public documents or doing stuff on public cases. So there's a privilege that attaches to that. And in those instances, it doesn't necessarily need to be verified. It has to be a verified court document, but it doesn't. The allegation itself doesn't have to be verified. You still want to present it as being towards one side, or just an alleged thing, but you get a little bit more latitude towards printing those sorts of things. Other reporters go through this. It can be a very, very rigorous process, and then at the end of the day, the editor and the journalist and they make a call. They say, should we go ahead on this? And usually it is. There might be some things that get changed, but overall, it prevents a lot of the things. And the one other thing I will say about pre-publication review is that it can be very important when it comes to insurance. A lot of insurers actually require the pre-publication notice, and that plays a part later down the road.
What can I say about pre-pub review? So we do it for a range of media companies, from the very stories for the very greenest reporters at the very smallest market television stations, up to really in-depth enterprise stories where maybe a cease and demand letter has already been sent in anticipation of the story being released, and so a lawsuit is probably coming. I mean, just some really high-level thoughts is, especially for when you're vetting a story for a pretty green reporter, precise writing solves a lot of legal issues, right? And so often I find what I'm saying to a more junior reporter is you just need to do a little more legwork on the reporting, and you just need to write this better, and you actually need to be more precise in what you're saying about this person as opposed to vague about what you're saying, right? Precision often avoids a defamation issue. I mean, the other thing we say, and I'll get back to actual malice because that's what this is about, but we also, so often these TV stories especially will start a woman, tells us that she doesn't have a home even though she paid $50,000 in a down payment to a contractor, right? And then, quote from the woman and some natural sound. And so my first question is always, has she filed a lawsuit? And sometimes the answer is yes. And it's okay, well, let's just quote the lawsuit, right? Because then you have a privilege to report on. It's called the fair report privilege, and you can rely on what's been filed in court as opposed to just sort of the extemporaneous speaking by the woman. So a lot of what we do is advise journalists just attribute back to a public record, right? And then, as I said sort of at the outset, there are important stories where you don't have public records. Me Too being an example. And so in that situation, you're looking for, okay, how many people said this to you? Not just one person, but 2-person and 3-person, and they're all on the record, and they're all willing to have you use their name. And not only did 3 people corroborate it, but this one woman who's claiming that, so-and-so raped her 20 years ago, she actually has an email or something that she sent to a friend at the time, right? I mean, these are the things we look for those trickier stories. But I agree with the prior panel and those who have vetting experience. Very rarely do you ever, never with the reporter have I said, you're good to go because of the actual malice standard. Now, I might say to the in-house counsel who calls me afterwards and says, how nervous should I be about this story? I might say to them, look, for a host of reasons, even if we miss something, I don't think this person is likely to sue, right? One being they're a public figure who would have to prove actual malice. But that's not the conversation we have with the journalist. And someone said on the prior panel, no journalist wants a correction on a story they wrote. And so the journalism ethics and the standards of the organization always adhere to a higher standard than actual malice permits if you get sued.
So when Randy was kicking us off, he sort of mentioned that this subject is ripped from the headlines, right? And whether it's the Johnny Depp Amber Heard case or the Sarah Palin New York Times case, you can hardly click on a news site these days without seeing a defamation case. But of course, the elephant in the room is the Dominion Voting Systems Fox News Network case that's pending now in Delaware Superior Court. This was filed in March 2021 by a provider of voting machine technology that claims that they were defamed by news reports on Fox that called into question the integrity of their voting systems. Rod, I know you have some thoughts on this. I just want to sort of uncork the lid here and invite you to comment on what your thoughts are on that case and what it says about this larger subject that we're here to talk about.
Well, thanks. You're giving me an opportunity to quote somebody that I watch every week, and that's John Oliver. And he says that Fox News' name is even a lie. because they do not provide news nor foxes. And the thing that's interesting to me about this case and the way that the attorneys are going about it is that so much of it is for the public. It's they want to call out Fox News and call out their practices, and that's, I think, is equally as important to them as trying to win the lawsuit about defamation. I mean, when you think about all the things that they're saying about the Fox hosts lying about how they really feel about Donald Trump, how they really feel about whether the 2020 presidential election was stolen or not, they don't really seem to go at the heart of what they were defaming, their claim of defamation, which is that the voting machines were, adding votes to one column and taking away from another. So a lot of that is just for the public. Fox News has apparently a business model that permits and encourages them to lie, so long as that's what their audience wants to hear. And as the director of ethics at SPJ, it's kind of hard to really deal with Fox, because every day we can say something, well, they lied about this, they lied about this, So, and I think that's true of much of the media that covers news organizations. It's just too much. It's just this deluge of lies every day, every week, that you just can't waste your time saying every day that Fox News lied again. The thing that I hope doesn't happen here is that for those people who are consuming the information that's coming out as a result of the depositions and filings, is that it confirms for them that this is how news media works, which is absolutely not true. There is not, the closest thing that I can think of that Fox aligns itself with is the National Enquirer. I mean, that's what we're talking about here. We're not talking about legitimate news organizations who are out to inform and inform people with truth, which is the role of a journalist. We are truth tellers. We are not just saying things that we think that our audience wants because it helps us financially. So I don't know how this thing is going to shake out, but I'm really glad that part of what's coming out is exposing to people who didn't know what Fox really is all about.
Other thoughts on that case? Anybody else feel like weighing in?
Well, it's ironic. One thing that I'm going to be writing about in the next few days, actually, is that when we talk about actual malice, famously, it's about knowledge of the truth or reckless disregard of the truth, and I know that a lot of lawyers kind of correct people on it doesn't necessarily mean ill will and everything like that. But the funny thing about this case is that honestly, I think that the ill will standard is being not talked about as much. I think that the common law definition of malice is going to play a much bigger factor in this case than most people think it is, and that's for one reason. To get punitive damages, I think you need to show common law malice, and I'm as bad as Fox News looks in this case. I think they have a real uphill road when it comes to, convincing anyone that they aren't liable for this. On the other hand, I think Dominion has a tough road ahead when it comes to showing the damages that they've incurred. They have a few $1 million in lost contracts, but they're pinning everything else on of what they call lost enterprise value. And I'm not sure whether the judge is going to accept that. The big question is going to be punitive damages. And so the big issue in the case, if it gets to trial, I think, is going to be, can Dominion show that not only did Fox News, recklessly disregard what Giuliani and Powell were saying on air. Not only did they have knowledge of Trump's conspiracy lies and all that, but the question is, did they intentionally want to harm Dominion? So that's something that I think everyone should watch.
I have a couple thoughts on the case. I mean, what you're reading in the media, right, are what we call bad facts in the business, and they matter, especially in front of a jury, right? I would be very worried to go in front of a jury with the record you're seeing. But, you're reading these media reports and you're seeing these bad facts, but ultimately, Fox could prevail on appeal. And I would go back to what Matt said, which is you don't get to mix and match the elements of a defamation claim, right? So if you've got a list of 40 statements, you don't get to say, well, this one's false but not defamatory, and this one's true but defamatory, and they really tried to dig in the knife when they said it. And this one is false and defamatory, but it's not actually about Dominion. And and you go through the list, and then suddenly you have a defamation verdict for Dominion, right? Think of it as a matrix where for every statement you have to check a box in every single column for every single element, and it's only the statements where every box is checked for which damages should be recovered. Juries don't get that. A lot of judges don't get that, but that is what the law says, right? And that is how I think, despite what we're seeing in the media, if I were representing Fox and I'm not, that's how I would argue the case. The other thing I would say is what Eriq said, which is I think we've all reached the consensus in this room today that defamation law is being used for leverage and to change the narrative. But if you think about what defamation law is supposed to remedy, right? It's supposed to remedy your reputation and potentially compensate you for business losses. And I am curious to see Dominion's causation case on that front. And then I would just pose this question to the group, right? People sue and they bring these suits because they want to restore their reputation. But did the Johnny Depp Amber Heard trial and the verdict in that case change anyone's mind in this room, right, about the culpability of either party? Whatever happens in Fox and Dominion, is anyone's opinion of those two parties going to be changed, right? I just don't know that defamation law is designed to be the vehicle for how people are using it. I think for private party plaintiffs, there's intentional infliction of emotional distress claims. I think sometimes defamation really does cause emotional distress. And then for corporate plaintiffs, you got to show business losses arising from this stuff because corporations don't have emotions to damage. So that'll be the challenge for Dominion.
I just wanted to pose one more question to Lieta and then reserve our last 15 minutes to throw it open to the group. But you mentioned that there's a defense to a defamation claim having relied on an accurate report out of a legal proceeding, and Eriq mentioned that that's why his lawyers love him so much, because that's what he does all day long, is accurately report on legal proceedings. If 15% or 16% of the cases are getting dismissed on Sullivan actual malice grounds, then that means that lots more cases are getting dismissed for other reasons and on other grounds. So can you talk a little bit about, sort of as a litigator, well, what are those other doctrines and those other defenses that protect publishers? Because the law is sort of built, right, to be protective of publishing and the ability to make an honest mistake, especially in the heat of the moment. So what are some of those other defenses that you would typically find yourself relying on?
Yeah. Truth is a big one, right? A lot of the frivolous defamation cases, you can look at the complaint itself and file a motion to dismiss and say, what we said is true, right? And the plaintiff has to prove it's false, and they can't do that either because they concede it's true in the complaint, or there's judicially noticeable records that you can point to. So you always like to win on truth, right? That's great for everyone except the plaintiff. The fair report privilege is a really big one, and it's why we encourage journalists to rely on public records, rely on official government statement, go and get the court file, right? Because if you are quoting directly from those and attributing it back and fairly summarizing what they say, that is a pretty ironclad privilege in almost every state. The opinion defense, we don't always like to do that. Front page news isn't supposed to be opinion, but some types of content, you can say this was more of a news analysis piece. This is opinion. So there's a host of defenses available. The actual malice one is nice because coupled with Iqbal Twombly, it is a quick off-ramp in what can prove to be a very, very expensive lawsuit if it's available to you.
Yeah. All right, so with that, would love to hear from the audience about their questions, comments, thoughts.
Who wants to go first?
A couple hands on my right.
One thing that neither panel has really focused on is the different regulatory mechanisms that apply. You've got the FCC regulating some of our media, and you can't say certain words on those media, and then you have the cable, and they don't have the same constraints, and that applies to words as well as sex in terms of what's to be televised. And now you have the internet, which is totally private and without regulation as far as I can see. Should that be true? Should we have those different levels, putting aside the defamation issue and the New York Times case? But it seems to me that part of what we ought to be worried about is, are we going to leave the open-ended internet totally private and rely on these? And another issue that you've touched on is, shouldn't the rules be true across the nation? It's a republic, it's a democratic republic, and should we have a different rule in every state for defamation? Shouldn't we have a national rule, because most of it is in interstate commerce, as opposed to having each state having a different level? And I know that's a political question, but it seems to me that that's, particularly on the internet pieces, that's the heart of what we're worried about, is leaving it to free, unregulated, free enterprise with some dominant figures like Elon Musk, as an example. That's kind of an open-ended question, but why are we having those different levels?
A huge set of questions. The panel after lunch is specifically focused on social media. I'm sure we'll get into this there, right? But one of the things the Supreme Court has emphasized in their relatively few forays into online speech is that they're not prepared to recognize any kind of step-down level of protection just because speech happens to be on the internet rather than on the pages of the New York Times. So that's the ACLU Reno case is the principal case for that proposition, and they've reinforced it several times since. So while you're quite correct that the court has been willing to recognize a step-down level of protection in the limited context of FCC regulated over-the-air broadcasting on the theory that you're using a public resource because those are scarce public resources, those licensed airwaves. That's the one and only one context in which they've been willing to recognize kind of a carve-out for a diminished training wheels level of First Amendment protection. But either Eriq or Lieta, do you want to take a crack at that bundle of questions?
Well, come this afternoon, it sounds like, right? But just real quickly, I think there are real serious questions, right, about the very powerful platforms and who gets to say, who gets to be on them and what they can say. I think equally important is the debate surrounding Section 230 and should those platforms be liable for the speech of others. But then as to your point about it's all interstate and we need some federal guidelines, I would just say I'm all for a federal law as long as it's a good one.
I'll just quickly add that there was a time when the FCC tried to invoke some sort of fairness doctrine that compelled broadcasters to present both sides of certain issues, and that went away. And some people credit the rise of right-wing media with the going away of the fairness doctrine. It's just an interesting, I don't know, historical note.
Thank you. I had a question about pre-publication review and how that plays out in breaking news stories, and are there more defamation cases that arise from breaking news stories just because of the nature of it? And what can a journalist do to protect themselves?
I don't know that I know if more defamation cases arise out of breaking news or not.
I think breaking news tends to be less investigatory.
Yeah.
So and there's a sense that a lot of different news outlets are doing it, and so as a news organization, when you're seeing 500 other news outlets cover something, it emboldens you a little bit. So for various different reasons, I think that there's a feeling that there's less liability when it comes to covering breaking news.
Although the Nicholas Sandman
cases,
those were breaking news.
Right, exactly.
And everyone got sued. And Nick Sandman's doing okay for the rest of his life. So I think, as a journalist thinking about avoiding litigation, if you feel you have a sensitive story, you talk to your editor about it, right? When I sit down to do a pre-pub, right, I always think about who are the potential plaintiffs coming out of this. And often it's not the subject of the story. It might be a peripheral person, right? And so you just have to think deeply and aim for accuracy, because that's always the safest bet. And then attribute wherever you can. Those are my 3 tips, I guess.
I will say this, that at the Associated Press, there have been stories that were breaking, that the content was considered either too sensitive or somebody might have some type of problem with, that we did have lawyers to take a look at it, even in an environment that a story is breaking. And of course, if you're familiar with AP, AP constantly is updating their stories, and they point out whatever they changed because it was inaccurate or for whatever reason. So I don't know how much protection that gives them, but that's something that they always do too.
Yeah. Breaking news gets vetted all the time. It's not like because it's an emergency, it doesn't go through lawyers' eyes. And a lot of news organizations have signed up for hotlines, so there's always someone on call to grab it. Some
states also have laws that compel the need for calls for retraction. So just because you publish something doesn't necessarily mean that will be your last call on whether that information stays there or not. There are corrections that are made or amendments that are made that kind of shape the liability issue moving forward.
The one thing I would add to that, right, where the breaking nature of the story gets factored into the equation is at the element of fault, right? So in order to carry your burden as a plaintiff, you must show false statement of fact, identifiably about the plaintiff, that caused damage and was made with some degree of fault. And it's that last factor where the court will bake in some consideration of, was this or was this not a fast-breaking news event, right? Because the degree of diligence that you're going to be expected to use as a journalist will vary based on, right, if this is a explosion in an oil refinery, well, I can't necessarily wait to get all my phone calls returned. By golly, I've got to report on that explosion as it is happening, and if I get things wrong, as they were saying, right, you update it, you correct it. But if it's an enterprise story, an in-depth investigative investigative story 6 months in the making, right, then the idea that, well, I placed a phone call to the subject of the story and I waited one afternoon before getting the call back, right, will not probably carry your burden of showing that you used reasonable care in pursuing that story. If you've been working on it 6 months and you waited until the very last hour, the very last day to get the response from the target of the story, right, that's a factor that would go into that fault calculation. So that's where the breaking or non-breaking nature of the report gets factored in. Yeah, I got several.
You touched on this just briefly, but I'm wondering if I'm wondering if corrections are part of, or retractions are part of the toolbox for maybe defending perhaps preemptively against defamation lawsuits, and whether that influences maybe the policies in place for corrections, how they're, policies surrounding when they're implemented, how they're implemented in organizations.
Yeah, so first of all, news organizations, the reputable, responsible ones, want to run a correction if they got something wrong, right? And they'll just do that whether they think litigation is coming or not. Corrections, clarifications, retractions can and often are used to fend off a lawsuit. But what I would say to the journalists in the room is, like, don't write a correction without talking to an editor and legal, because I had a case very recently where there was like one correction and then the correction wasn't quite right, so then there was another correction, and it just kind of got worse and worse and worse, and then there was like 15 emails for every correction talking in the newsroom without cover of privilege, like how they messed up, and it was just kind of ugly. So corrections can be great, done well.
Actually, and talking about a correction that wasn't done well, if you look at that Rolling Stone case, that's how they found actual malice. It was not necessarily the original publication of that story about the rape. It was the correction that was appended afterwards, where where the jury saw that and they said, oh, well, they left the story up. They could have done this sort of thing. I've had conversations with counsel where I've gotten, requests to change a story that's been published like 3-4 years ago, 5 years ago, and I've recommended that we not make any alterations to a story based on the simple worry that will reset the statute of limitations on a piece, particularly when it comes into the internet. So I think there are times when you have to be very careful about corrections and updates. Of course, you want to do that, and ideally you do it quickly, but there are certainly other considerations to think about.
The New York Times, Sarah Palin's lawsuit against the New York Times, the Times had run a correction immediately. I think it was maybe the same day or the next day on that. I don't know if that made a difference, though.
Probably becomes evidence that they were reckless in the first place, that they didn't fact check. So there's always dueling arguments for and against doing that sort of thing.
Okay, go ahead, yeah.
Hello. I was just curious, you mentioned that, actual journalistic standards are usually higher than these cases kind of bring. But I was just curious, we know that journalism newsrooms are kind of shrinking across the country. There's a lot of these smaller newsrooms, and I'm curious how powerful these cease and desist letters are, even if it doesn't, quite escalate to that kind of slap lawsuit standard. How chilling are these, lower standards that, hey, cut it out, we don't want this to come out? How chilling is that for these smaller newsrooms who just don't have this counsel readily available?
What do you think?
I think they can be really scary. I haven't seen a smaller newsroom just automatically pull something because they get a letter. Now, in all honesty, a lot of the smaller newsrooms I work with, we represent pro bono, right? And so I think if you're at a startup, make sure you have insurance, make sure you know who's going to represent you, make sure you know you can afford it. So I think they're scary. But if you have good counsel, you can address a cease and desist letter pretty quickly in most cases. And if it goes beyond that, you just want to make sure you have insurance.
You know, there was a time a couple of years ago when I searched for what are called robot.texts on certain websites, because one of the trends I've seen is that, you know, not only do you get cease and desist letters telling you not to publish something, but I've seen cease and desist letters that tell you to put the code in so that the search engine doesn't index it. And you can go to some of the smaller websites and look to see which of the articles are not being indexed by Google and other search engines, basically because they've been you know, pushed by powerful people.
That's really interesting. So you guys are in newsrooms, and you talk to a lot of newsrooms, and with kind of the raising the temperature of defamation cases, is there anything different that is going on there in terms of discussions and questions that you're getting from editors and reporters?
Yeah, maybe this is because I'm in Minneapolis, which has been sort of the epicenter of things the past couple of years. I hear from a lot of startups and nonprofits that they want to change the narrative. And it is well-intentioned, and the narrative probably does need to be changed, but when they say it, it often means they just want to report things without as much substantiation, and it makes me really nervous. And I mean, their point is we can't wait for the official police report on this because we can't trust police reports anyway. You know, see what happened to George Floyd, where the police report was a lie. So we're just going to go with this story, and we're going to talk to the person on the street who's calling it a murder, and it's okay to quote him calling this a murder, right? And the answer is no, it's not. Like, calling someone a murderer before they're convicted is highly defamatory. And so that, to me, has been one of the biggest challenges, is people wanting to change for legitimate reasons how journalism is done, but not recognizing that the law has developed around how journalism has been done and hasn't caught up with, or cannot maybe accommodate, changing the narrative. I don't mean to be flippant. It's like, it scares me because I want to support these journalists who are trying to do this, but like, they're a little bit out on a limb legally sometimes.
I'll just say my personal curiosity is how this coming era of artificial intelligence and ChatGPT contributed facts and stories contributes to this whole discussion, because I think that we've barely scratched the surface of you know, the technology that is to come and how it's going to shape the newsroom and how we consume news.
Well, I haven't been in a newsroom for almost 5 years now, but in my role as Director of Ethics and Diversity, I think some of the inquiries that we get have to do with content that's online, particularly how you deal with social media posts that somebody might put up, or also is a social media platform different than your primary platform, things like that.
All right, thank you very much, Frank. Panelists, terrific job.